So what happened to the movement in 2012? Everyone said, what happened to the movement? Well, it was suppressed by the IRS. So this was a massive suppression of the Tea Party in a way that benefited, not coincidentally, President Obama's reelection campaign. I told you a few weeks ago that there was a big transparency ruling in Obama IRS case that we had participated in, and the ruling was going to require the disclosure and the unsealing of the deposition transcripts of Lois Lerner, who you all know about, and another woman who you may not know about, Holly Paz, P-A-Z, and both of whom were in the middle of the Obama IRS suppression of the Tea Party. Also, other documents were released because there were documents that relied on that deposition testimony that the parties had filed that were also unsealed. And it's a big deal. And the documents further confirm the abuse of the Tea Party, the knowing abuse of the Tea Party, and a cover-up of that abuse. The documents were unsealed in a case that happened out in I think it was in Ohio, the NorCal Tea Party Patriots versus the Internal Revenue Service. The records were back from 2017, and the court outrageously had been sitting on it for 4 years. The court wasn't ruling on the effort to unseal this. So the plaintiffs, if I recall, sort of mandamus of the court, meaning they asked the appeals court to say this judge needs to act. This is not right. So the judge finally just ordered the release of the records. The sworn depositions, as I say, were given in 2017 by Lerner and Paz, and the two IRS officials repeatedly have memory lapses in the depositions, which is, par for the course, and regularly plead ignorance about the fundamental matters that they were being paid to handle on behalf of the U.S. taxpayer, meaning the efforts to stonewall, and in many ways harass those seeking 501c4 applications approval from the IRS. Now, 501c4 is a type of IRS it's a definition that the IRS uses to define what is called social welfare organizations. And these are groups that can involve themselves in politics much more than a 501c3 can. Like, they run ads usually about attacking politicians or raising issues. They can't necessarily say vote for or against someone, but they can get much more political. Judicial Watch, for instance, is a 501c3 educational foundation, so we can't do those types of ads by law. And back in 2010, when this scandal first started, there was this big decision out of the Supreme Court the left went crazy about, essentially affirming the First Amendment called Citizens United, which allowed for much more participation by Americans in the political process. And the left obviously doesn't like that for reasons that we can spend a lot of fun explicating, but I'll leave it for you to understand that instinctively. And so not being able to get the feds by law to restrict free speech, they used the IRS as a backdoor way to suppress these groups that were trying to assert their First Amendment rights. Now, you may, those of you who are students of politics closely, you may remember that the Tea Party emerged around the beginning of the Obama administration, and their activism, which was anti-government spending, generally opposed to Obama administration policies, helped result in a big win for Republicans in 2010. So what happened to the movement in 2012? Everyone said, what happened to the movement? Well, it was suppressed by the IRS. So this was a massive suppression of the Tea Party in a way that benefited, not coincidentally, President Obama's reelection campaign. So we know what I love about Mitt Romney, by the way, when he poo-poos President Trump's concerns about the abuse of him in 2016, it's like Romney is not self-aware enough or doesn't know enough about the way things operated to recognize that he was also abused when he was running against Obama, because they were targeting people likely to be supportive of him and to be active on behalf of his issues in the election campaign. It was election interference as much as it was election interference when the FBI and DOJ were harassing and spying on Trump, and when they were suppressing Hunter Biden information in 2020. So you had the IRS doing that work for Obama in 2012. That's why they did it again in 2016, because with the abuse of the FBI and DOJ, because it worked. So these are all the records we got. It's 500 records. And they include the deposition transcripts, and these are what the transcripts look like. And I encourage you to read them all, because I'm not going to be able to, in the brief time I have, to describe all the good stuff in here. But I encourage you to read the Holly Paz deposition transcript. You'll see it easily available. I encourage you to read the Lois Lerner deposition transcript. It'll take a few hours to read it, but I read it. So if I can read it, you can read it, right? And also, I encourage you to read, shortly after the transcripts, it's a big file, 500 or so pages, essentially what the plaintiffs allege based on the evidence in terms of the misconduct of the IRS in the abuse of the Tea Party and their clients. And it's called the Plaintiff's Statement of Material Facts in Response to IRS Statement of Proposed Undisputed Facts. So that's a technical way of saying this is our story. So some of the details include in Holly Paz deposition, the one that I noted is that one of the big lies they put out there is the reason they couldn't deal with all of these Tea Party applications because they were overwhelmed by the large number of them. Well, that was a lie. Holly Paz's deposition shows that the reason they didn't handle these Tea Party applications is because they had one application initially that they thought was important vis-a-vis the Citizens United case, meaning they were hesitant to apply it because they didn't want these C4 groups to operate. So they stalled on handling this one application, and they were depending on that analysis to handle all the other C4 applications. So it wasn't because there was this large number and they couldn't deal with it. No, they didn't want to approve any of them. And that's confirmed in this deposition. Also confirmed, Holly Paz acknowledges that the applications as they were made to the IRS required them to approve them, that there was no basis to not approve them. Question: the organizations had filed applications representing what they were organized for and what they have done, and also their intended activities. And you thought that for the majority of those applications, that would warrant the recognition of exemption, meaning application approved. The witness, Holly Paz: my recollection is that at the time, my thinking was that the majority of the C4 applications, while they may have indicated some amount of political activity, that we would not have had enough basis to make a determination that would be their primary activity and deny them exempt status. And therefore, they would receive an approval or recognition of exemption. Correct. There you have it. They knew they had no basis to deny these applications approval. Instead, they stalled and delayed and stonewalled and harassed them with questions about what books they were talking about at their meetings and other irrelevant information. Also information about their donors. They had no right to get information about the donors in the way they were asking, and they acknowledged that in these documents that I'm talking about here. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.